Good morning, good afternoon, and good evening, wherever you are. Good morning to our guest speaker, Professor Souichirou Kozuka from Gakushuin University, Tokyo. Good morning to our Dean, Dr. Idris SHMA. Good morning to our Head of Department, Transnational Business Law, Dr. Prita Amalia. Good morning to our moderator today, Mr. Mursal Maulana SHMA. Thank you very much. And good morning, good morning to our participant and welcome to International Public Lectures in Harmonization of Transnational Business Law with Japan Perspective. Before we begin, I would like to make some arrangements you may follow. Please follow the instructions to change username below, name _ institution. Example, Thomas Nailendra from Unpad. We are recommend you to active your video during the session and please mute your audio during the session. You may activate your audio when asked by Master of Ceremony or moderator. In order to see the speaker in full screen, please select speaker view instead of gallery view in the upper right corner of your Zoom screen. Participants who have the questions may deliver questions through the chat in the chat box, or if you want to deliver the question directly, please use the raise hand feature. And the second, and furthermore, I will like to invite Dr. Idris SHMH to give the welcoming remarks on this session. To Dr. Idris, the floor is yours.
Okay, good morning, and of course, we are saying all the praises and the thanks to Allah, our God. Yes, today is a good day because Department of Transnational Business Law have successfully invited international expert in law. This morning, of course, we have just attended the lecture. The topic regarding SPS, sanitary and phytosanitary measure. This agreement, of course, is part of WTO agreement, Marrakesh Agreement 1994. Anyway, of course, I appreciate again for the international lecturer, prominent lecturer, Professor Souichirou Kozuka, Ph.D., Gakushuin, University of Tokyo. So my colleague, Dr. Prita, candidate Dr. Helita, Pak Mursa, Taufik, and of course my great student. Thank you. Welcome to our university. And your topic from the professor is talking about harmonization, of course, between national legal system and international. In this context, if we are talking international transnational law, is of course WTO or EMA, IVRD, Unpad, UNCITRAL, and others subject. So I'm saying that no state will be big state without trade. So of course Japan is leading country in trade. Yeah. So of course the material might be given by a professor. I think it gives us advantage not only for me but also for my student. So please, my student, you can ask more about the subject because this is good for your final assignment or for a journal, join writing, join smear and others. Anyway, Prof, again, thanks so much. I hope this seminar is not the first time, but I hope the department might follow the next for academic activities. So WTO or Transnational Business Law is the most important for us because now Indonesia has good hope because Indonesia now is part of 2020 And of course, I hope Indonesia will be bigger country and supported by my network, my leading country, Japan. In academic perspective, of course, this is insight. This is current development from professor, and I hope student can take advantage of this seminar. Thank again, thank all participants, my student, enjoy the lecture. Thank you. Assalamualaikum warahmatullahi wabarakatuh. Selamat siang. Keep a spirit, keep fighting, keep healthy, and again, thanks so much.
Thank you very much, Dr. Idris, for your kind words. And I agree, this is a terrific moment for our students to have the knowledge directly from the expert. Now, furthermore, I would like to introduce our moderator, is Mr. Mursal Maulana. And let me to introduce Mr. Mursal. Mr. Mursal Maulana SHMH obtained a Bachelor of Law from the Faculty of Law, Universitas Syah Kuala in 2014, and complete the Master of Law at the Faculty of Law, Universitas Padjadjaran in 2017. And since 2018, Musa Maulana has been a permanent lecturer at the Transnational Business Law Department by teaching several subjects: international law, international trade law, international investment law, international contract law, comparative contract law, arbitration and alternative dispute resolution, and international economic law. Besides, Mr. Musa Maulana is also a researcher at the Center for International Trade Law and Arbitration Studies, Faculty of Law, Universitas Padjadjaran. Without further ado, I give my baton to Mr. Musa Maulana to lead the discussion today. Thank you very much.
Thank you, Pak Taufik, for your kind introductions. And hello, everyone. Welcome back to the International Public Lecture held by Transnational Business Law Department. Today, we are about to discuss quite interesting topics. It is the harmonization of the transnational business law with the Japan perspective. And we are quite fortunate today because we have the Professor Souichirou Kozuka that has joined with us today. Hello, Professor Kozuka.
Hello from Tokyo, and it's good to see you, and it's good to meet all those students at the Transnational Business Law Faculty of the University of Padjadjaran. Nice meeting you all.
Okay, Professor Kozuka, and today's topic is quite interesting. You know that harmonization of transnational business law is play pivotal roles for every sovereign state in order to modernize their national law, and also harmonization can play an important role in making like a modern legal system in every single state. And without further ado, please allow me to introduce Professor Souichirou Kozuka. Professor Kozuka is professor at Gakushuin University, and he specialized in commercial law, corporate law and maritime, air and space law. He also edited implementation of the Captain Convention and the domestic law on secure transaction in 2017 and was published by the Springer, and also published the selective reception of uniform law in Asia in Japanese Yearbook of International Law, volume 60 in 2017. And Professor Kozuka is correspondent of Unidra, an association of member of International Academy of Comparative Law. And for our students, please utilize this opportunity. You may ask the questions and also explore the current development of harmonization after Professor Kozuka presents his presentation. Professor Kozuka, without further ado, the screen is yours for today's sessions.
Okay, thank you very much for the Dr. Musa Maulana for kind introduction, and hello again to all of you participating in this seminar. And I very much appreciate being invited to this wonderful occasion. And I had been a frequent traveler to various academic opportunities before 2020, but suddenly, and due to this COVID-19 pandemic, and my life has totally changed since more than 1.5 years. I have been stuck in Japan. So this is one of the very exceptional occasions in which I can communicate with a non-Japanese friends of mine. And although I cannot physically be in Indonesia, which is very regrettable, and especially I have never been to Bandung. I have been to Jakarta, but I have never been to Bandung. So it should have been a good opportunity for me if this were to take place physically. But yes, let's hope for another occasion. And for today, and I am talking to you from my office in Tokyo. So let me share the slide that I prepared. Where are they? Okay, good. Oh,
okay.
Okay. I think it works. Dr. Maulana, does it work?
It does work, Professor Kozuka. It can be seen by all students and in the screen of our participant.
Okay, thank you very much. Thank you. So, so I'd like to give you my thoughts about harmonization of transnational business law. Well, as already kindly mentioned by Dr. Maulana, I have been a correspondent of Unidra, which is the international organization for the harmonization of law since almost 2 decades. And I have also worked on the Cape Town Convention, which is one of the feature product of Unidra, and even edited a book on that. And to this book, and your colleague and Dr. Prita Amalia kindly contributed a chapter on Indonesian law. That is really appreciated. And in fact, that is the contact that had brought me to this opportunity. I thank you very much for that, Dr. Prita Amalia. And having said that, and I must confess that I am not 100% satisfied with the classic or traditional theory of harmonization of law. And I have always thought that the traditional view is very much European centered, and it does not fully reflect the viewpoints from other regions. Given that I am a Japanese by nationality, and I usually think about Asian perspective, but I have tried to think about other regions as well, such as Africa or Latin America. So today I'm going to talk about first what has been done with regard to harmonization of transnational business law, and then introduce my thoughts about that, and with some questions or doubts about the traditional theory. Okay, so first, what has been achieved. So the unification is the older term. And in fact, unification of law started in late 19th century. And in those days, of course, the origin was Europe. And in those days, and the idea, the target to be achieved was the world law. So, and European people in those days, of course, when European people said world, it was mainly Europe and not literally global. But anyway, so they thought that if they could have one set of legal system and covering all the countries and at least all the major countries in those days, then that should be the idea. So that was the beginning of this idea. So, but 19th century was kind of the heydays of a strictly defined sovereign states. So it was not easy for the lawyers in those days to simply establish discuss and a draft and a uniform law. So and the approach they had adopted was to hold diplomatic conferences from time to time, which as time passed developed into international organizations and to produce international conventions that cover certain aspects of a transnational business law. So, and as students of the Transnational Business Law faculty, you may know the UN Convention on Contracts for the International Sale of Goods, which is more known by its acronym CISG than its full name. And CISG is, yes, that is widely accepted. More than 80, almost 90, I think, states have ratified this convention. But still it covers only the sales contract, and it covers only the international sales contract, so not domestic sales contract. And so the scope of application is very limited. And also Cape Town Convention, which is one of the another very well accepted international convention on security interests in high value mobile equipment such as aircraft. And yes, there are 80 odd states parties to the Cape Town Convention, but still it covers very specific subject of security interest in aircraft or aircraft financing. So, and that is the reality. So, and in that sense, the idea of a world law has not been achieved. And still lawyers, academic lawyers in particular, talk about transnational commercial law, which is very similar to transnational business law. And it is even claimed that nowadays, and almost every aspect of a transnational commercial transactions is covered by this type of international conventions or model law or a model contracts or something global or something universal. So there is no room as far as international commercial transaction is concerned. There is little room for domestic law to play, which claim I have some doubt about, but that is where we stand. Okay, so and I already mentioned that and the production of a harmonized instruments for international commercial law or transnational commercial law and has moved from the hands of ad hoc diplomatic conferences to international organizations. There are three major international organizations of that kind. So the first is the Hague Conference on Private International Law, which was established in 1893, and now a permanent entity and with 89 member states plus one regional organization, which is European Union. And Japan is a party. I don't think Indonesia is a party, but anyway, it is an organization with wide participation. The second is Unidra, whose English name is the International Institute for the Unification of Private Law. And it started as an auxiliary organ, so it was kind of attached to the League of Nations before the Second World War. And when the World War broke out, and it turned itself into an independent organization. Now it has 63 member states, and Indonesia as well as Japan are member states to this organization. It is based in Rome, not least because Italy, or in particular Rome, is the mother region for the Western legal system. And it is in fact housed in the medieval and a medieval house of Italian aristocrats. And this is a photo that I took when I visited the headquarters of Unidra. So the building itself is kind of a historical building. ASTRA is more recent. It is one of the commissions under the General Assembly of the United Nations. And of course, that is the product of after the Second World War. And as the Commission of the United Nations, ASTRA is open to all the member states of the United Nations, but the member states of the Commission are limited to 60, and the votes take place every 5 or 6 years. I don't remember exactly, but to select the member states and from of this committee. So, and as a result of the activities of these international organizations, as well as other more specialized organizations such as ICAO, International Civil Aviation Organization, or IMO, International Maritime Organization, or CMI, Comité Maritime International, which is a non-governmental organization with longer history. And there are 100 odd conventions, model laws, and guides and adopted for harmonization of transnational business law. So, and there may be a few more instruments that have been adopted in the last 5 years. But in 2017, when I wrote an article on the reception of these uniform law instruments or harmonized law instruments, and there were 114 of them. So, and I made kind of a survey of these international instruments and examined to what extent these instruments are accepted, and to see whether there are differences in the attitude or in accepting these and harmonized transnational business law instruments, and depending on the regions in the world. So that is the topic of the second part of my talk. I use the word reception because acceptance is more kind of a technical word. It's one of the formalities of signing the international convention. So I use the word reception to denote states and having ratifying or acceding to or recognizing these conventions, and in the case of model law, implementing them in the as part of the domestic law. So, first of all, in the world, there are 201 jurisdictions. The number is larger than the number of member states of the United Nations because some international organizations accept 2 or more jurisdictions as members to its meetings. The famous example is Hong Kong and Macau, which are part of China, but still they have independent seats in several international organizations. There are also some other examples as well. And Asia occupies 26 among them, and Europe has 50 jurisdictions. So I started comparing these 2 regions. And as I mentioned, so there were 114 harmonized instruments at that time. And so how many of them have been received, have met reception of these jurisdictions? The average was, as you see, 1909. So even though there are more than 100 instruments in the world, and on average, states receive only 19 of them as the ratified conventions or implemented domestic law and based on the model laws. And there are very significant differences among the states. So the largest, the jurisdictions with largest receptions were France and the Netherlands, and both have 56 harmonized instruments received in their jurisdictions. Whereas some other several jurisdictions may have made no receptions. Eritrea, Somalia, South Sudan, well, partly because they are rather new states and partly because they are rather isolated in international relationship and have suffered from civil war. And yes, Timor-Leste, and that is also a very new state, so that's no wonder. Anyway. And then having closer look at the instruments. And among the 114 instruments, there are some instruments that are very popular, like New York Convention on the recognition and enforcement of international commercial arbitration, which 158 jurisdictions have made reception. So this means almost universal. The same with the Warsaw Convention on International Carriage of Air, which is a rather old convention, but a Montreal Convention of 1999, which is a new convention to replace Warsaw Convention, has also met 124 receptions. So this is also very popular. And some other conventions you see and have found more than 80 receptions. So I have named them as must-have instruments. So if your state wish to play some important role in the international trade, then these conventions are must. There are 13 must-have conventions, according to my count. So, with that basis, and let's compare Asia and Europe. So there is a striking difference in the attitude towards a harmonized transnational law conventions, transnational commercial law conventions, and between Asia and Europe. First, the average number of receptions in Asia, it's 1404, whereas in Europe, 31.02. And in Asia, the jurisdiction which has made largest number of receptions is Hong Kong, which is actually a bit tricky because Hong Kong has made succession of the ratification from the time when it was the colony of the Britain. But anyway, and Hong Kong is the top and it has made 30 receptions. So look, so in Europe, the average number of receptions with regard to a transnational and a commercial instrument is 31, which is larger than the Hong Kong's reception, which is 30. So Europe's average is larger than all the Asian jurisdictions and receptions. And there are also some difference between with regard to which conventions are popular, which instruments are popular in Asia and in Europe. So in Asia, for example, New York Convention is very popular. Yes, that's obvious. You need this convention if you want a foreign investment, and that is the same in Europe. But for example, at the end of this list in Europe, and there are 40 jurisdictions that have a ratified CISG among 50 jurisdictions. So 40 among 50. So 80% of European jurisdictions have ratified CISG. Whereas in Asia, it's only 6. So 6 out of 26 Asian jurisdictions. So CSG is not very popular, I would say. And I must say that even Japan ratified CSG only as late as 2008. So it's been just 12 years since our Japanese ratification of CSG. So it was very, very late. So, there are some differences in which instruments these jurisdictions are interested in. The difference is even clearer if we exclude must-have instruments, because must-haves are anyway must-haves. So any major state need to receive these instruments. So if we put this aside, then with the remaining 101 and a non-must-have instruments, and Asia on average receive only 7.23 instruments, whereas in Europe, 20.68. So it's more than double of the average of Asia. And in Europe, and a major Hague conferences conventions, so a private international conventions like service abroad, taking of evidence, and protection of children convention. These conventions are rather popular, whereas in Asia, popular instruments are e-commerce model law of ASTRA, arbitration model law, and Cape Town Convention. So it's more, say, economic and a financial and instruments that are popular in Asia. So, you may have, by the up to now, this point, you may have had the impression that Asia has not been very enthusiastic about a harmonization of transnational law, transnational business law, and that. You need at least some nuances to that impression. And actually, Asia has made, from their perspective, and has made participation in the harmonization efforts. So even before the Second World War, Japan, as one of the few independent states, we were very fortunate, and a few independent states in Asia, Japan tried to join the European states in the harmonization effort. So it was as early as in 1904, that Japan requested participation in the Hague Conference, which is much earlier than the United States, and I thought even earlier than the United Kingdom. And similarly, in the maritime law world, Japan set up the Japanese Maritime Law Association and became a member of the CMI in 1901, just 1 year after the Americans set up a US Maritime Law Association and joined ACMI. So, in the starting point, at least Asia was not behind the Western states. And that is not the only contribution to harmonization. Still, in the quantity or the volume of a participation, Asia has been less represented at Uniform Law Organization. I don't think that is due to Asian states. It's rather more historical, and due to the historical context, and with the Europeans founding these organizations. But anyway, and members of the Hague Conference, Unidra members, and also ASTRA members, and having relatively small. And Europeans always say that there is almost hardly any regional efforts toward unification, and that is true. Still, Asian jurisdictions often look at harmonized transnational business laws as models when these Asian jurisdictions and reform their domestic laws. So when China codified their contract law, which is now civil code, and they closely traced Unidra principles and CSG. This is a very famous story. And when you examine Chinese maritime law, Korean maritime law, and even the Japanese maritime law, most recently amended in 2019, and no, 2018. And these reforms or codifications have been heavily influenced by international conventions. So, and it is not that Asia has turned their back to harmonize transnational business law, but the attitude has been different. And so how to interpret this situation? This is an open question. So, and you may have your interpretation of this situation, but I have, say, 4 ideas at this point. So number one, Asians, including Japan and maybe Indonesia as well, and are more pragmatist. So as I said, and Asian jurisdictions have more interest in economic and financial instruments rather than a procedural and a private international law instruments. So we are more pragmatic. We want something beneficial if we were to accept something global. Otherwise, we are happy with our national laws. That may be one thing. Another, although closely related issue is what does the private or commercial law mean to our society? In Europe, it is often said that law is the basis of the society. And from that perspective, perhaps eliminating the difference means that eliminating the distances between the society, which means the people in different countries becoming closer and maybe achieving a peaceful world. So, and we see that Europeans have been moving in that direction, although going backward and forward, and with the European Union, and which is now the real thing. But in Asia, so do we, for example, think about Asian Union covering China, Korea, Japan, Indonesia, Vietnam, India? Do we want that? Probably we would say, So, and that may be a viewpoint. So in Asia, law is something more instrumental. Law is for a particular purpose. Like say we want law reform, we want to update our obsolete law, and for that purpose, a harmonized transnational instrument is very useful. Or we may want something new, like say we want more finance for our airline industry, or we want more investments in e-commerce, then Cape Town Convention, then e-commerce model law, e-signature model law. So and that kind of instrumentalism concerns about how we look at law, or what does law mean to our society. That brings me to the third viewpoint. So, and you may not know this very much, but we have kind of suffered from this. So, and there has been a long tradition of Western, in particular, American and also Australian lawyers who study Japanese law and say, oh, the role of law in Japan is very different from the Western world. So a Japanese people's legal consciousness has been their favorite subject. But I don't think that is unique to Japan. I think that is more a difference between Japan and between Asia and the West. And so at some point in my research, I came across with this and a historical fact. So before the Second World War, so most of Asia were colonized, and there were many Western powers in this region. Still, there was a kind of a regional economic connection. So the focus was a hub was Singapore, and from Singapore to the US, there was an export of rubber. Why rubber? Because in the US, there was the automobile industry and they needed tires. So to produce tires, they needed rubber. So and rubber is grown where? In Indonesia and also in Malaysia. So products were grown and collected in Indonesia and Malaysia and brought to Singapore, and Singapore was the exporting port. And then there were people who worked in those farms or plantations. So, and of course, local people may have worked, but also a Chinese migrant forces, migrant laborers came and worked in these farms. So there was a human and a movement and in this region as well. And people needed clothes to wear, which were produced by Japanese and also Chinese textile companies. And people needed food, which was the main food was of course rice, and it was produced in Thailand. So there was this regional economy, which is similar to the current European common market. And Europeans always say, oh, to achieve a common market, we need harmonization of law. That is why Europeans need European law. Okay, that is good. But before the Second World War, in Asia, we had this type of regional economy and the laws were different because we were unfortunately colonized, and a British law, Dutch law, French law, Thai law was a mixture. Thai was independent, and Thai law was a mixture of common and civil law and also Japanese law. So is law a necessity for the regional integration of economy? So the role of law in the society differs depending on the context or depending on the culture. So this is the third viewpoint. And the last, but no less unimportant, is the influence of the United States. From Europe, United States was a rather new emerging power in the world, at least in late 19th century and early 20th century. But in Asia, US was from the beginning a very strong actor. So they had the West Coast, and from the West Coast, they approached Asia, they approached Japan, they approached China, they approached Southeast Asia. So US influence is very strong here. So I have asked my colleague in empirical political science, and I asked, can I examine the patterns of ratification, patterns of reception in Asia, and patterns of reception in France, UK, Germany, and US. And he did that. I didn't. I'm not a statistician, but he did that, and what he found was here. So the correlation between Asian and US reception is 0.61, whereas correlation between Asia and France was 0.33. So an Asian pattern is closer to US pattern of reception than major European jurisdictions. And And at some point, I compared Asia with Latin America because Latin America is unique in that the whole region is almost civil law. So the traditional argument is that there is common law and there is civil law. Among civil law, there is French law and German law. So we need unification. And so in Latin America, it does not seem that they need, at least their need for unification is lesser than in Asia, where common law and civil law coexist. But the outcome was the opposite. So apparently there is something different from the traditional argument. So that introduces us to the historical and conceptual insights into the background of harmonization of law. But I have already covered part of my argument. So let's review the argument. So traditional understanding was that, and so harmonization is necessary to eliminate the differences. So difference itself is a problem. More recently, and people say, oh, there is an economic term called transaction cost. So if you come across with a new legal system, every time you trade with a new partner, that is a cost. Maybe so, but if that is the only reason, then, as I said, with regard to Latin America in comparison to Asia, so the more legal system coexist, the larger the need for harmonization should be. The outcome is not always as such. And also, a harmonization effort itself has changed. So recently, international organizations have shifted from simple unification to more law reform. ASTRA, Unidra, even the Hague Convention, Hague Conference, excuse me, and look at this law reform. And a Cape Town Convention as a signature product of Unidra is it has been produced as an instrument for law reform by design, because a Cape Town Convention introduces very new original rules to the sector of aircraft financing and security interests. Some part of it is similar to the US law, but not entirely the same, and overall, it is more kind of an original set of rules. So it is not like, say, old, say, maritime law or old Hague Conventions, which say, oh, this is a common law rule, this is a German rule, this is a French rule, so let's take the middle. That is the old way of producing and a harmonized transnational law instruments, and a Cape Town Convention is not like that. So what has led drafters of the Cape Town Convention? Economic rationale. So what kind of rules are acceptable to finance industry? Why do we care a finance industry? Because they provide money. So, and if something is not satisfactory to finance industry, they hesitate extending credit to the industry, which is our problem, not their problem. And if we do not get money, it is our problem. So in that sense, acceptability to financing industry is not for their sake, but it's our industry's sake. So that was the concept. That was the concept to design the Cape Town Convention. So that is the argument of law reform. So Matthias Sims, who is a German academic in comparative law, now teaching in England, and he has this concept of better law. So a better law, according to Matthias, is divided into three categories. So one thing is something is already there, but it is out of date. So you need an improvement. Okay. Second category is there is a goal and the existing law does not match this goal. So let's make it more suitable for this goal. So the policy goal is clearer and the law needs to be amended to achieve this goal. And third thing is, a goal itself is out of date. Like say, it used to be said that, oh, debtor and creditor, these people have a conflicting interest. So you need balance between these two. But as I said, more recent view is that, okay, so a creditor satisfaction is the debtor's interest. So there is something common rather than conflict among these two parties. So the goal has been replaced. Okay, so any type of better law requires law reform, and law reform to be guided by this by this goal or the target of achieving better law. So now we see that the logic has changed. So it used to be that a difference among legal systems is the problem, and we need to eliminate this difference. And now we are talking about which is the better law and which set of rules do we want. If the best set of rules is something not existing in the current legal system, why not create that new system? So that is the more modern approach to harmonization of transnational business law. So this means that the approach toward harmonization has moved to our the pragmatic approach, which, as I said, is more kind of closer to Asian people's view at private or commercial law. So I have theorized it in this manner. So when European people started talking about unification of law, the assumption was that law was a nation state's law. So a nation state is the number one, it was a state, sovereign state, and a sovereign state was almighty. So it monopolized the power of lawmaking. So the only way to harmonize its laws was the diplomatic conference of sovereign states. Now, in the 21st century, sovereign state is not almighty, although it is still sovereign, and we are not almighty. And now there are regional integration, and now there are international fora. States are talking about, say, climate change. States are talking about, say, a pandemic. States are talking about, say, the world welfare, and sovereignty is limited by various considerations. So now the situation has changed. And in 19th century, it was not only sovereign state, it was a nation state. So the concept, this is the concept, so not the reality. But the concept was that there was some group of people who can be regarded as nation. So maybe sharing common values, maybe sharing common culture, and maybe sharing common policy goals, possibly. So France is one of the typical example of nation state. Belgium, the Netherlands, Italy and Germany established their nation state. And this was the concept. But now, that is rather the minority among the about 200 states in the world. Japan is more, say, nation state, but say Indonesia, I understand in Indonesia, the slogan was the integrity among divergence. So you recognize yourself as a state with divergence, and say the United States, which is very much a kind of a divergent society, Brazil, and then say South Africa. There are, I think they have 11 ethnic groups in the state. So nation state has become now the kind of outdated concept, and in two directions. On the one hand, there seems to be kind of the division within the society. As in the US, there are Trumpists and anti-Trumpists, so division. But on the other hand, as in Europe, so the sharing of value has crossed the border. So now the value is shared within the region and not within one state. So anyway, so the concept of nation state has changed. And finally, the law. So law has become now more instrumental and more pragmatic, as I have already argued. So just by using a figure, so classic model was that nation state, nation as a unit, and sovereign state, which was a inviolable, and then private law was more kind of the social element. Whereas the modern model is that nation and a social value has gone beyond or divided within a nation, and sovereignty, it is not absolute now, and many things have become a matter of international concern, and private law has become more instrumental or pragmatic system. So this is the background. This is the background of the shift in the approach to harmonization. And this may be the background for the differences in the attitude toward harmonization. So if you stick to the classic or traditional argument of, okay, so if there are differences among legal systems, let's have something common and to harmonize these rules. I don't think that will be successful. And I don't think that will be something that we look for. And what we look for is a more suitable to this modern system of changing meanings of the commercial law, which is in some sense, which has gone beyond national borders. In other sense, it has a different or I would say limited role in the society. And so if something fits into this new context, then that kind of harmonized transnational business law is most welcome. And I think the successful instruments, in particular Cape Town Convention, and or more classic example is New York Convention for International Commercial Arbitration. So these are have been successful because they have met the demands of this new situation of the national commercial law. And with that in mind, I will quickly look into the interpretation issue of harmonized law. So people often complain that after some convention or model law is adopted, then the work stops there. Whereas in the case of domestic law, and the story starts there because the courts start applying these laws and deciding cases and based on these laws. But in the case of transnational commercial law, adoption of law is the end of the story, and the interpretation is left to national courts, which is a more kind of a diversified system. And that complaint sometimes leads to this type of provision. in CISG and also in the Cape Town Convention, in other uniform law instruments as well, in the interpretation of this convention. Regard is to be had to its international character and to the need to promote uniformity in its application. And there is sometimes even the online collection of cases interpreting these conventions. But my doubt is it really useful? Because as long as it is after all the national judges that apply these instruments, even though these articles give them a caveat, still, as long as national judges apply and interpret these provisions, then they are affected by the style of judgment writing, which legal philosophers sometimes call legal reasoning. And this style of judgment writing or legal reasoning is rooted in the legal culture. And so in another article of mine, and I examined the history of legal education in Japan, and I found very interesting thing. So in Japan, how to write judgments is taught at law schools and also at the Legal Research and Training Institute, which is a more professional training organization established under the Supreme Court. And this is kind of a handbook. And this handbook has been updated and updated. So the most recent version is very new, but it dates back to the middle of the 20th century. So what does this handbook say? So it gives tells the judges about the metastructure of the judgment, and then it also tells the judges to gives them the guidance about fact finding. So okay, fact finding should be detailed, but should not be redundant. The facts found should be limited only to those facts that are relevant to the decision. And there is a formula, in Japanese it's called yoken jijitsu. I can't translate that into English. And this formula, use this formula. And also, fact finding is more important. So interpretation of statutes should play less role in the courtroom. It is more kind of an academic work. So a primary purpose of court procedure is solving the dispute. And so that is what this handbook tells the judges. So yoken jujitsu formula, what is it? I said, and I can't translate that into English, but I can explain it. So, and it is kind of a stylized formula, and with statutory provision or code provision, and it gives guidance to judges to apply these provisions to actual case, which are the facts that parties should prove. So which party to prove is the issue of burden of proof. And this is universal. And what is unique to Japanese judges is that which facts are to be proven and which are the facts that are not relevant to the application of this statutory provision. This is very much stylized and very well organized. So, and this is an interesting thing is, so this is just an example of yoken jujitsu for a contract of sales. And if you apply this yoken jujitsu literally, then the famous issue of battle of forms disappears. And I will not go into details, but this is very interesting. So, what I have found is these are kind of very technical things. These are not law. These are just guidances, guidebooks, handbooks to professional judges. So very technical things. But as a result of the learning these technical materials, judges have their own Japanese approach to the writing of decisions, which is not universal at all. So even the same text could result in kind of a different application or different interpretation, which I think is best described by this term, legal format. Legal format is a word invented by a famous Italian comparative law scholar, Professor Sacco. And a format is originally the kind of a medical or biological term. So you hear my voice now, but and the voice comes from my throat. But if you have something directly to my throat, it should be simply oh, and cannot become a word. So it turns into a word, and because there is upper throat and there is mouth and there is nose, so these parts make the sound into a words and or voices, and that element is format. And so law is the same. So text is something like the sound from the throat. So the law in the real society is transformed from these legal texts by the addition of these legal formats. This is the argument of Professor Sacco. So the judges' handbooks, the guidances, the guidebooks are just like that. So, and as long as these exist, then I don't think unification in interpretation and application of harmonized law is possible or achievable or even desirable. Okay, so and what I have talked about today. So number one, uniform law. It has a long history, and it has gradually shifted its focus from unifying, eliminating the difference, to harmonization, to better law reform. And perhaps in relation to that, the attitude toward uniform law differs. So in Europe, they are basically they make more kind of reception of harmonized law instruments, maybe because they still believe in the classical argument of uniform law. But if the focus of harmonized transnational law is the law reform, then the things should be more pragmatic, and which is the situation in Asia. And number three, it reflects, after all, what law means to the society and what we expect from the law. So it relates to the meaning of the law, and it is closely connected to the concept of the nation state, which has also experienced transformation, significant transformation in the last century. And finally, and in arguing this harmonization of transnational business law, we should not forget about how judges apply and interpret these rules. And so in that context, and a comparative law studies is very important. One last word is, if you still want to find uniform interpretation, the only thing is to escape from national court and national judges, which is commercial arbitration. That is why international business people often favor international commercial arbitration. It is a national tribunal, so free from national legal culture, and could be the national kind of a vacuum of a legal system. So thank you very much for your attention. And if you are interested in the stories that I have talked about, then these are the writings of mine which you may find interesting. So thank you very much.
Thank you very much, Professor Kozuka. What a comprehensive presentation for today's lecture. I think 1 hour, it has emphasized 3 topics that can be taught for 3 sessions in our program. And Professor Kozuka, thank you. This is quite informative and quite helpful for our students to understand the concept of harmonization. Professor Kozuka, before we give the floor to our students, let me ask the question regarding to the terminology used in harmonization itself. You know that historically, the harmonization appears because of, you know, that there is a fragmentation of the legal system in every single jurisdiction, and you know that harmonization appears, and some organization trying to develop or to create international treaties and any other kind of. But Professor Kozuka, there are any other terminology used, for examples, convergence of law, and also legal convergence, and also you know that localized, and also you know any other kind of like unification. But unification a bit sensitive, you know, that it is a little bit difficult for the state to try to unify. But Professor Kozuka, do you think that the concept of harmonization, particularly in Asia countries, like you has been present, like is there any possibility for the private institution like international chambers of commerce that has make a like soft law instrument? Is this will be difficult, and you know that the intention of the countries is quite different based on their interest. But my question is how soft law instrument that has been popularized by the private institution like ICC can be accepted by member state. Professor Kozuka.
Thank you very much, and that is a very interesting point. And so, first of all, yes, and the use of the term harmonization instead of unification, which is more classical, may connote that not only the international treaties, but also a soft law instruments like a private, a collection of terminology or model contracts or private rules like the Uniform Customs and Practices for Letters of Credit, and also on the state level, model law are included in the world. So harmonization is broader and harmonization is softer. And I think that is so softer or kind of flexibility is only half of the story. And given that the shift of the unification harmonization has taken place from eliminating the difference to achieving the better law through law reform. Because so model contracts, model law, and even the collection of terminology, these have some policy goals, because in the case of international convention, kind of ironically, and that inevitably impacts a domestic law once ratified. But this type of soft law has no direct impact. Yeah. So if it were to make sense, it must have some policy goals. So in that sense, the form is soft, yes, indeed, but the message is even stronger. So it is not a simple compromise. It shows you what the law should look like. So, and by using the term harmonization, it may also connote, and I'm not denying the aspect of flexibility, but also connote that a harmonization of goals. So we need to look at the same target rather than looking at different things and simply make compromise. So that is a big change in the approach toward the subject. That's my understanding.
Yeah, thank you, Professor Kozuka. Dear all students, now the Q&A sessions. You may ask the question either.
Pak Mursal, maybe we need a photo session first before the Q&A.
Oh, okay. Before embarking on to the Q&A session, perhaps Professor Kozuka.
Okay, I stopped sharing.
Okay, for the documentation for this event, this is today we have to take the picture. For the participant, please to turn on the camera, and Pak Taufik will lead us to this photo session. To Pak Taufik, the screen is yours.
Thank you, Professor Souichirou Kozuka and Mr. Musa Maulana. And to all participants, please turn on your camera. I will take the pictures on my Zoom meeting screen, and I will waiting for any second further. So maybe you can prepare yourself. Okay, great. I will count into 3 on my mark. 3, 2, 1. Thank you. And the second screen. 3, 2, 1. Thank you very much, Mr. Musal. I give my baton to you.
Okay, thank you, Pak Taufik, for the photo sessions. And now we are moving to the Q&A sessions. For the all students, you may raise the question by raising your hand feature, or you can use a chat box to deliver your question. And so far, there is a question from Raffi Andiansyah. Raffi Andiansyah, you may deliver your question directly to the Professor Kozuka. The screen is yours.
Thank you, Pak Mursal. Thank you for going to answer my question, Professor Kozuka. Yeah, so my question is regarding something that you mentioned earlier, with there being different reception for different types of uniform law attempts. What would be the determinative factor, do you think, in your opinion, as to why certain attempts of unification are more well received than others? Like why is, like for instance, something along the lines of the CISG or the Cape Town Conventions are something that is well received and adopted and implemented in different states, but others which seemingly are also they have the same amount of perhaps deliberation and drafting effort, so to speak, put into them, but they're not as successful or as adopted. Is it just a matter of if states, they feel like it, they just adopt it, or they feel like this is something politically useful that they might get it? But what do you think is the most important factor in determining which one is more widely adopted and which one is not? Thank you.
Okay, and that is a very interesting question, and thank you very much for raising that point. I think there are a few points. Number one is the economic benefit from from receiving the instrument. So New York Convention is a typical example because it is often required by foreign investors as a condition for making investments in that jurisdiction and that economy, I would say. And there is a direct economic benefit expected. Cape Town Convention is similar to that. The second aspect, viewpoint, is the reciprocity and the economies of scale. And if you become part of this group, then you are in a better position. And if this group becomes larger, it will be more beneficial. So this is the case with the air law protocol, for example, like Warsaw Convention or Montreal Convention. And because if you are not parties to these conventions, you do not benefit from their liability regime, including the insurance. And same with the Apostille Convention, which is very technical, but very important for making the international trade easier. And also slightly different a sense, but a slightly different context, but a oil pollution convention like CLC, a civil liability convention for oil pollution in the sea, or the fund convention for compensating these oil pollution. In order to get compensation, you need to become a member. You need to be a party to these conventions, and you need to become a member of the fund. So, and otherwise, your state should by itself fight with any pollution that takes place in your territory. So, and this is also economies of scale. That is the background. And the third thing is sometimes US pressure, political matter. And that is the background why I mentioned the stronger US appearance in Asia as compared with Europe. So some conventions like e-commerce, a model law, or say even in the family law field, a child abduction convention, which has been strongly advanced by the US. And so, and for political reasons, states have chosen to be parties to these instruments. The only exception, and for which I have no explanation, is CISG. CISG is non-mandatory rules. It's simply a sales contract, no direct economic benefit, and no economies of scale. And although US itself found its benefit interest in CSG, and it was one of the original ratifying states, still, and it has not exerted a strong pressure on other countries for ratifying. So I don't understand why CSG is so popular, but it is popular. This is the exception.
Okay, thank you, Professor Kozuka. Hoping that the answer can be satisfied you, student. Professor Kozuka, while we're waiting to other students to ask the question, perhaps there's a question from Ibu Prita. Ibu Prita, this is your time to ask the question to the Professor Kozuka. The floor is yours, Ibu Prita.
Thank you, Pak Mursal, for the opportunity. I'm just some follow-up questions from the previous concern from Raffi and Prof. Kozuka give the example on the New York conventions, Captain conventions, as well as with the CISG. But then I would like to ask about the method of the harmonizations, Prof. Kozuka, because if we comparing between the CISG and the Captain conventions, I think that the CISG is one of the convention that one of the purpose is to unifications. Not for the harmonization. Even in the Article 2, in the scope of application, there's some opportunity for state to use the CISG as the choice of law. And this is, I think, the first step for the state to still use the CISG, but then not as a contracting parties. But then one of the interesting from the Captain Convention that we understand there's some another approach that Sandel give the method of, this is the new method of the international law, whether there's an umbrella conventions, and then under the umbrella convention, there's some numbers of the protocol, and there's some mechanism or there's some system rather than the reservations if we understand on the international treaties, but what the Captain Convention use is the declaration. In this method that the state could raise or could propose some declarations in the implementations of the conventions. There's some four, if I'm not mistaken, there's some four method. First is opt-in, opt-out, mandatory provisions, and there's another method. Don't you think, what I would like to ask is, do you think that this is some method that we could use in terms of the harmonizations, Prof. Kozuka, since I think when we talk about the transnational business law, it would be quite challenging for us to unification or to unify all the law in the in one time, for example, like CISG, we need more than 30 years to have 94 contracting state rather than the Cape Town Convention when the move is quite faster than the CISG. Prof. Kozuka, thank you.
Well, thank you very much. And of course, you are an expert in Cape Town Convention, so I have nothing to add to you. But yes, in the case of CSG, I think their policy goal, they did have policy goal, but their policy goal was only one thing, that is the freedom of contract. And we should remember that CSG was adopted in 1980, and which was still the time of Cold War. And in particular, also in the Soviet Union and East European countries, but in particular in China, they were very in a primitive and a stage of move toward a market economy. So it was just a few years after Deng Xiaoping and tried to open its state to the world economy. So and yes, in fact, I have interviewed some Chinese experts about the time of ratification, and they told me that in 1980s, they had no freedom of contract. So contract was always kind of a prepared format at at one of the national companies, state-owned companies, and people had to just fill in the quantity of the goods want and the price they will pay, and that was all. So against that situation, and to introduce the idea that all contracts can be freely negotiated and agreed, and once agreed, it is binding, that was important. So other parts were kind of less relevant. I wouldn't say no meaning, but less relevant. And so, and in that respect, CSG is very strong. But from other aspects, and it is not very strong, and also parties can derogate from CSG. And if parties choose to derogate from CSG, that is the extreme of freedom of parties. So that's no problem. And in the case of Cape Town Convention and other recent international instruments, I think the target is more complicated and more technical. And as you see, the insolvency regime under the Cape Town Convention, that is very, very complicated, and I don't think I understand fully what they mean. And so they try to, on the one hand, they want to have these complicated rules to be implemented as they are. And on the other hand, they wanted to deal with those who are not satisfied with these ideas. So they invented this system of opt-in, opt-out. And so it's kind of a very well thought about, but I think it's a bit too technically drafted instrument. And a model laws, like say ASTRA's model law on secure transactions, its predecessor, of course, is ASTRA legal guide to secure transactions, and that is a more kind of a common approach to the subject, I think. So, and a model law shows these are the basic rules, and you are suggested to take them as such. But if you think you wish to deviate from this, you are free to do that. And so that is kind of opt-in, opt-out. Still, and with the model law and the explanatory note behind that, and if the national drafters want to derogate from the model law, they need some justification for why not to follow this model law, but to choose another rule. So that may be kind of the softer and a shape of Cape Town Convention, which is very, very, very strongly pressuring.
Thank you, Prof. Kozuka.
Okay, thank you, Prof. Kozuka. for your response to the Bu Prita questions. And so far, there is no other question from the students. While we are waiting, Professor Kozuka, I also want to raise one more question regarding to the interpretation, like what you mentioned previously. You know that in Japan there is a formula that so-called the Yuken Jujitsu that you have explained is quite comprehensively, and I think this is can be the example for Indonesia itself. You know that after Indonesia ratified a treaty, particularly, for example, in commercial treaties, and you know that there is the problem in domestic level, how the judge interprets the treaty based on the original intent of the treaty itself. But in Japan itself, the Yuken Jujutsu formula, has it been recognized or has it been implementing as like jurisprudence, or every single interpretation must be based on the Yuken Jujutsu formula in terms of interpretation when the judge can get difficulties in understanding this concept? Perhaps you can explain much detail about the Yuken Jujutsu formula. Has it been recognized as the concept that must be implemented in the court, or just the voluntary when the judge has nothing to do with that? Thank you, Professor Yuken.
Okay, thank you very much. And because I rather made a rush to talk about a Yuken Jujutsu, and if it gave you all the impression that it is a formula to implement international or transnational commercial law, and that is not what I meant. And that is Yuken Jujutsu is basic to our legal system, and more used with regard to, say, civil code or commercial code. And it kind of forms the judges' approach to applying the statute text to actual case disputes. So, and even when the judges are applying international conventions or harmonized transnational law to actual disputes, they have a similar approach that which they are familiar with through the dealing with cases under the domestic cases under the civil law, civil code or commercial code. That is what I meant. And yes, Dr. Maulana, you are a question concerned about how these formula are implemented. And they are actually the materials for education of lawyers. So at law school, and also during the traineeship period, after passing the bar exam and before being appointed as judge or lawyer, and then in early years of the judge's career as well. Japan is I think Indonesia is the same, but in Japan, it's a career judge system. So people start their career as judge from from very young. It's not like common law countries where old lawyers become judges. And at law schools, a traineeship, and also in early years of being a judge, and they are trained by these handbooks and guidebooks, and kind of become quite familiar with the formula. So after, say, 10 years having been appointed as judge, and they may kind of fully aware of these formulas. So they do not need to look up the handbook every time. So they already know how they use. So, and at that point, when judges become fully aware of these formula, then they can use the same approach even if there does not exist a formula as such. So that is when these judges apply and interpret the harmonized transnational local instruments to actual disputes. So it is very strange because these instruments are drafted in a very different approach from the Japanese domestic laws. So it is very strange to apply these Yoken Jujitsu type formula to transnational law instruments. But yes, they tend to do so.
It is like the benchmark like that, Professor Kozuka, for the Yoken Jujitsu.
Yeah, yes, it's kind of like that, yes.
Okay, thank you, Professor Kozuka, for your result. Perhaps there is no more question for the sessions. And finally, we come to the end of this session. And before I close this webinar, I would like to highlight some conclusions from what the speaker has presented. Professor Kozuka has presented the first regarding to the history of the harmonizations. It began since 19th centuries when International Hague Conference on Private Law, and after that following by other international organizations like Unidra and ASTRA that had promoted some international convention that need to be instrument for the harmonizations. Regarding to the reason for the harmonization, there are traditional and modern approach in which both kind of the reason it has similar objective, that is to make the more modern legal system in every single states that want to harmonize its domestic law. And the most critical point that Professor Kozuka highlights is in interpretation of the harmonized law. This is a very, very important point that we need to consider, because every treaty stipulate a particular article regarding to how to interpret the legal, for example, in TISG, in Captain Convention, and anyone else. And also, I also appreciate what Professor Kozuka has been done regarding to his extraordinary research regarding to the 13 must-have instrument. This is also quite important for our student to make to dive much deeper based on Indonesia perspective, how many treaties that has Indonesia harmonized with its national legal system. This is quite informative, Professor Kozuka. Once again, Professor Kozuka, thank you for these sessions. Hopefully our student can understand. And I think this is quite comprehensive and quite extraordinary for us to having you today. And once again, thank you.
Thank you very much for inviting me to this occasion. And I hope that my talk raised some interest or a concern in the subject among the audience, young lawyers from Indonesia. And I look forward to the occasion that when you become a matured lawyers and collaborate with the Japanese lawyers. I hope that my arguments, my research can shed some light on the subject you will deal with in the future. So that should be the largest pleasure to me. So thank you very much again for inviting
Professor
me.
Kozuka. Looking forward to seeing you in another our webinar series. We can discuss another topic regarding the transnational business law. Okay, I'll give the floor back to the Master of Ceremony. Thank you.
Yes, thank you very much, Mr. Musa Maulana, and thank you very much to Professor Kozuka for your wonderful lectures today. And I get some many insightful knowledge from you. I hope it could be useful for the day of tomorrow, for the welcoming for the future. Sorry, and now we will going to the next session is a closing remark, which will be delivered from our department, head of department transnational business law, Dr. Prita Amalia. Dr. Prita Amalia, the screen is yours.
Thank you, Pak Taufik, for the opportunity, and thank you very much, Prof. Kozuka. Very interesting lecture, comprehensive, insightful, and everything. I don't know what the suitable word could because it's really I really enjoying the session since talk about the harmonizations is very relevant today. And yeah, what Pak Mursal said, I totally agree that this is a very fundamental topic that the student could learn to understand further about to what extent in the future the transnational business law will develop and will comes up with another convention, and how us or how Indonesia and we are as a student, as a lawyer, maybe in the future could respond in the development of transnational business law. And I think rather than the unifications, harmonizations is quite plays the important role in the development of law. And yes, hopefully the student could get the information, because this not only about the introductions of the Japan law system, but then Prof. Kozuka give more than only introductions about Japan law system, even with the theory to what extent that Japan responds in terms of the harmonizations. And we are understand exactly because we use the same conventions in the class, like CISG, Captain Conventions, and New York Conventions in terms of the arbitrations or international commercial arbitrations. So it's really amazing, Prof. Kozuka. Hopefully in the next semester, we could arrange some similar event with Prof. Kozuka, maybe in the another subject. And I believe that this today lecture would be really relevant with next semester subject, comparative contract law. And Captain Convention could be one of the convention, talk about that as well. So Prof. Kozuka, thank you so much. I really appreciate your contribution to today's lecture. And this is a good start for our collaborations. And on behalf of the Dean, Faculty of Law, Universitas Padjadjaran, we would like to extend the certificate of appreciations for your contributions today. And thank you. And it is very wonderful. I'm speechless actually. Usually I'm with Prof. Kozuka every September in Oxford. We attend the Captain Conference academic project, and maybe next year, now we are moved from the University of Oxford to the Cambridge University. Hopefully that pandemic will end soon and we can meet physically, and Prof. Kozuka could meet us directly to visit the university and faculty in Bandung. Thank you very much. Stay safe and keep success. And thank you.
Thank you very much. And thank you for the online certificate. that was a surprise to me.
Thank you, Prof. Kozuka.
And yes, same to you. Let us stay safe.
Thank you, Professor Kozuka, and thank you, Dr. Prita.
Thank you all.
Thank you, Pak Mursal, Prita.
Arigato gozaimasu, Professor.
Thank you, Pak Taufik.
Arigato gozaimasu.
Yeah. Thank you, Prof. Kozuka. Have a nice day.
Thank you very much. So, okay.
We'll keep in touch